All right. Welcome, everybody. Welcome to Not Another Lunch and Learn every Wednesday at 12 o'clock to 1 o'clock. We bring a special guest here, a business associate, someone that's doing real estate investing here in Arizona to kind of share their expertise with everybody. So we're live on Instagram, we're live on Facebook. So if you're out there and you have a question, post your question in the comments. Rosa's here to help. She's going to make sure I get that question and ask Sam to get it answered. Obviously, if you're in the group right now, you have the chat box. So feel free to pop in your questions and I'll get them answered, or you can raise your hand. And if you're on Instagram and Facebook and you want direct access, you would to the Zoom link, you'd always have to sign up with AZREIA and register in advance. So I'm going to kick it off here. Our purpose here at AZREIA, we've been here since 2002, representing real estate investors all throughout the state. Our purpose here is to unlock and accelerate our members' ability to invest in real estate through education, market information support, networking opportunities, so you can elevate your financial well-being. We're here for you every step of the way. I'm going to take a few minutes before we bring Sam on, just kind of tell you about AZREIA and what we got coming up, and then we'll dive right into the basics of estate planning. So Monday, October 10th, in person at Venue 8600, the second Monday of every month, we do our Phoenix monthly meeting. It just happened this past Monday. This is the only event that happens in Scottsdale. Everything else is here at our local office in Central Phoenix. I'm excited for next month, as we have, as always, our market update. We have our market update and news is going to be with Tina Tambor of the Cromford Report next month. So make sure to be there. She gives a wonderful presentation, very in-depth and thorough. She's the #1 analyst in the state of Arizona. Then from there, we don't have an educator this month, but what we will do is be bringing in an expert panel. So what I'm doing is bringing in 4 people that are experts in their strategy. They're actually, doing live deals today, multiple deals. I have Steve Trang of the Real Estate Disruptors. He has a large wholesale company where he's going to be on the panel next month. Let us know how he's navigating. We have Zachary Keeps coming in. He has over 250 rental properties, and he's still buying in this market today. We have Brian coming in, who's doing 10 flips a month. We got Andrew coming in from People's Mortgage, who has over 400 lender products, and he's going to let us know how the interest rates and the loan processes are going for all these investment products. So it's going to be a great panel. So then Tuesday, October 11th, we're going to go down to Tucson, do the same thing. And then, as always, the Phoenix Real Estate Club is the 4th Tuesday of every month. So September 27th, it's coming up at the Phoenix and Tucson meetings. We throw a lot of information at you. You meet a lot of the business associates. You get the market update. You get the educators, the panelists. So we say, hey, take all that information, come down to the Phoenix Real Estate Club on the 4th Tuesday to our office in Phoenix, and we'll have a discussion. We talk about the deals our investors are doing today. You could see people doing mobile home flips, rentals, land flips, raising money, a lot of creative different deals. It's really cool to see how everyone's participating in real estate in their own way. It kind of opens up your eyes to a lot of different things, as well as we have the I Want, I Have session, where you get to have the opportunity to stand up and let everyone know what you need in your business and what you have within your business, so you can try to connect the dots in the meeting. So 4th Tuesday, September 27th, be here. That AZREIA Tucson. No, oh, you know what? See, I can't be the technology guy. You're seeing all my hidden slides. All right, let's see. Subgroups. We do our subgroups. We have about 15 events a month minimum, whether it's on Zoom or in person. So we have subgroups to cater to every investment strategy: fix and flip, landlords, beginner investors, raising money. We do a discovery session where Molly takes an hour and tells you everything about AZREIA and our website and all the benefits we have to offer. So we play the Cash Flow 101 board game. So we just launched the Southeast subgroup meeting as well, Southeast Arizona, which means in Bisbee. We have a meeting that represents Douglas, Arizona, and Sierra Vista. We started a women's group. We got a multifamily group starting as well. So a lot going on. You have to just go on to azreia.org/calendar, and you can see all the events that we have throughout the week. So love to see you at these events. This is a great, our business is 80% relationships. It's all about meeting other people and building your business. Anthony Chara was our national speaker who came in and talked about multifamily investing. He was with us in Phoenix on Monday, Tucson on Tuesday. He did a wonderful job, explained to you the importance and how valuable investing in multifamily is. I know we're more of a single family, small multifamily organization, but Anthony has owned up to 2,000 apartments. So it's amazing to see what he's accomplished over the last 20 years. So he's going to be with us next Saturday, September 24th. He's going to spend a full day with us discussing apartment investing. All this information is on our website. Then he'll also be with us tonight here at the office in Phoenix. So if you sign up and attend September 24th, you get to come tonight for free. So tonight, basically 6 to 8 o'clock here at the office, analyzing deals. It's all we're doing. Whether you have a deal that you're looking to buy, or you want to buy, or you just bought, you found it on the internet, whatever it is, he will analyze the deal. He wants to show you how to run the numbers so you buy the right deal. So bring leads, bring opportunities for him to check out. It doesn't even have to be in Phoenix. It could be in Florida, Connecticut, you name it. It doesn't matter. It could be a hotel. It could be a mobile home. He just wants to analyze deals tonight. So bring those and figure out how he does that. Launchpad group session is coming back up. We do this every other month right now. This has been going on for about 5 years. Basically, what we've noticed is as new real estate investors come into our organization, they want to, they're going on YouTube, they're chasing the shiny object syndrome, whatever it is, they just don't really have a path and they're trying to figure out how to gain some traction in their business. So we put together these 8 steps, a workbook, and you get to hang out with me for 4 hours and build that business plan. Okay. You're going to be able to walk out of there with these 8 steps. You're no longer going to be kicking the can down the road. You're going to be able to have a vision to where you're going. You're going to have a target to aim at. And you're going to gain that traction and momentum to get a deal done. So love to have you. That's October 29th, 9 to 1:30. It's $30 for AZREIA members, $100 for non-members. So there is a hint there. Core skill classes. These are coming up starting September 29th. Sam, can you hear me? I have a question for you.
Go ahead.
So when is anyone familiar with Jack Nicklaus?
The golfer? Sure.
Tiger Woods. You ever heard that name?
Yeah.
All right. So when those two gentlemen first met ever, what did they talk about? What was the first thing they spoke about?
Golf.
I love the answer. Very, very good answer. They discussed their grip and how they hold a golf club. They didn't talk about winning the PGA, all the championships they got, all the success they have. They talked about how they held the golf club. That's one of the most fundamental aspects of golfing. So we feel at AZREIA core classes, there's 5 fundamentals that you need in order to succeed and get a real estate deal done. Marketing, right? You got to have leads coming into your business. People need to know who you are, right? If you don't have marketing, your business is dead. So once those leads come in, you got to be able to analyze the deals, comping, estimating repairs. You got to know your numbers so you can write the proper offer to be profitable and successful. So once you get that offer analyzed, you're going to negotiate the deal with whether it's the homeowner, attorney, homeowner, agent, a wholesaler, whoever it is, you need to negotiate. So you need some fundamental skills there. And once you lock up that deal, you get to write that contract. And we're going to have Sam's business partner, Mick McGirr, come in for 2 hours and talk about contract basics. He hangs out with us during that class. And I know a lot of people, when they're new, they don't want to get in trouble. They think they might be doing something wrong. He clarifies all of that for us. Okay. And you get contracts along with attending the class. We'll give you copies of about 5 or 6 different contracts. And once you lock up that deal, you got to have the money. Where do you get the money, right? I'm going to go over some ways you can do raising private capital, joint ventures, but then we're bringing Andrew in from People's Mortgage, and he's going to discuss all the different investment products that you can leverage to get into these deals without a perfect credit score and all that stuff. So check us out. These are in person and online. So if you can't make it to the office, you'll still watch it on Zoom. Everyone gets a recording, whether you make it or not. And we have a bundle price, $60 each, that might be $320. You could buy the bundle price, all 5 for $225, and you could purchase those online or call the front desk. Rosa could help you out. AZREIA show, it's been going on for about a year now. We're on episode 42. all podcast platforms and our YouTube page. You can watch this. So we do member spotlights of members that are succeeding and doing deals. We also bring in our business associates. We bring anyone that is associated with Arizona and real estate investing. We bring them on the show to give you any type of information that we possibly can. Home Depot, if you're a member at AZREIA, we have the largest discount program in the country with Home Depot. So that relationship with Home Depot, as an AZREIA member, you get 2% back twice a year on all your purchases, 20% off all your paint. So as long as you have a Home Depot Pro account and your AZREIA account, put those together, you start saving money and helping your bottom line as an investor. So as a member, we'd love to have you. If you're new on Facebook, you're new on Instagram, or even on the Zoom call, we'd love to have you part of the community. We'd love to help you succeed in this business. So if you're not going to be a highly active member, it's only $100 a year. And if you do attend the events you do attend, it's a la carte, $5 subgroups, $10 for the big meeting. If you are highly active, which I hopefully you are, you're going to go out there and be a go-getter. You get to go to all the meetings for free for our Plus membership, which is $239. Both programs have access to all benefits. I just went over one benefit, and that's Home Depot, right? So we have a well over 30, 40 different local and national vendors who give you free trials, discounts, benefits for using their services. So there you go. Now, the main man, the main guest, Sam, we're talking about the basics of estate planning. So like I said, if you're online on social media, Instagram or Facebook, drop your questions. Rosa's gonna get those questions to us. So I wanted to bring Sam here because he's one of the best at what he does. And there's a lot here, right? Some of you might be like, what's estate planning? Why would I even do that? I'm trying to close a deal. We're going to go over why you need estate planning as a part of your real estate investing career. So Sam, if you can kick it off, because I know you like to kick things off.
Oh, I love kicking things off.
And so let us know who you are, what you're about. Take a couple moments to let us know who you are, and let's just jump right into estate planning, what everyone needs to know.
Yeah. So as far as the boring stuff, I'm a lawyer. I've been a lawyer since 2011. I started my practice working for the federal courts as a judicial law clerk, meaning that I was a lawyer who worked for a judge.
Okay.
Then once that was over, I moved back to Arizona, which is where I'm from, and started practicing in a real estate law firm. Did real estate for a while, in particular in the arena of homeowners associations, which is like kind of working for the Empire in Star Wars. It's, definitely working for the bad guys. I don't know a lot of people who appreciate HOAs. I certainly did not gain a very warm appreciation for them, working for them. But then I joined Phocus Law, and I got to pursue a lot of other different types of businesses that needed legal help. Like Mick and I remember when we were driving out to do some education at a prior firm, and we both were talking about what we would rather be doing than working for HOAs. And basically what we came up with was the conception of what Phocus Law is today. And of course, Mick kicked it off, and I joined him 3 years ago. And what we strive to do is solve all the problems that a small business may come across.
Okay.
From birth to death, from starting or registering your small business all the way through wrapping it up. And that includes litigation, it includes collections, it includes insurance issues, basically everything that pops up. That's why Mick is so good at the contracts. He wants to make sure you've got the right contracts in place for the management of your business. But what we found was, during the course of serving these businesses, the business owners were like, I've got all this wealth now, and I need to know that it's going to be protected for the next generation. And it's a very natural outgrowth of serving small business owners and small business interests to then also begin the process of estate planning and preparing those estate plans for our clients as well. So that's where I come in.
Love it.
You have all this real estate properties, and what's the purpose of having them? It's to provide for you and your family. It's to build wealth, generational wealth, and that's where estate planning comes in. You want to make sure that the stuff that you've built during your lifetime doesn't evaporate as soon as you die. And in order to do that, part of that process is putting together the right legal documents so that when you pass away, your wishes are honored, not only by your loved ones, but by the courts, by Arizona law, or whatever state you happen to be in. So how do we do that? I mean, the first thing that we do is we try to figure out what your primary considerations are. And Mike and I have had this conversation separately, but there's three primary considerations that we look at when we're handling an estate plan. And the first of those considerations is called probate avoidance. And for those of you who aren't familiar, probate is a legal proceeding. There's a probate court in Arizona, and just about every state has a probate court. And probate, the court is trying to determine three things. Do you have a will? Two, is it who are your heirs and creditors? And three, who gets what? And in the state of Arizona, that probate process, for the most part, is there's two different flavors, and for the most part, most of them fall under the informal probate category. Informal meaning that the court really doesn't have a whole lot of involvement in the probate proceeding, which is nice. The more that a third party, a court or a lawyer gets involved, the longer it takes, the more kind of document provision needs to take place, and it can just be really cumbersome. So the informal probate, just about every estate in the state of Arizona can qualify. And in fact, that's where you start, is it with informal probate proceedings. What happens to make it a formal probate, and thus the more kind of awful probate proceeding, is you may have something that complicates the matter. What does that mean? Well, according to the state of Arizona, that means either your will is questionable, your heirs are fighting over who gets what, or your creditors are fighting over who gets what. So those are the three main reasons why it would become a formal probate proceeding. Of course, you can also require a formal probate proceeding, though I don't know why you would, because it just means more assets, more money being drained from what you want your descendants or your heirs to receive. So formal probate versus informal probate, it's like night and day. An informal probate generally is wrapped up within 6 months, costs usually less than $1,000. I would say the usual cost is about $500 to $600, but it's definitely less than $1,000. Formal probate, sky's the limit. It really depends on how much money you have, and generally the legal fee is about 1% of your total estate. And it also takes a long time for a formal probate to wrap up. You're generally looking at a year minimum, 18 months probably more common, and then above 18 months is probably less common, but it's definitely in the realm of possibility. So that's the first consideration, is there a way, or does it make sense for me to try to avoid the probate proceeding because of, one, it's time consuming, and two, it depletes your assets that you intend for the next generation or two.
If I could jump in, Sam, and as real estate investors, obviously that's one of the motivation points that we look for, right? In our world, right? Someone going through probate, because it's a hassle, right? It's, someone didn't have a will, they weren't prepared, and it gives us an opportunity to help that family through the process and maybe allow us to buy the house. So I've seen a lot of these ugly situations where the family members aren't getting along, they're stressed, there's still mourning. And so it's a big headache. So what you're trying to do here with estate planning is trying to, on our side, since we're all here to buy a bunch of houses and build assets, we don't want our family to go through all that, right? It's essentially protecting all that for them as well, right? So probate, informal, formal. So what's next?
So that pretty much wraps up the probate consideration. There is another kind of flavor of probate, but it's really not going to be applicable to your members, I don't think, because in order to qualify, it's called a small estate transfer, and it's probate light. You really go to the court, and if you have less than $100,000 worth of real estate assets, you just file an affidavit with the court, and then they sign it, and then you record it, and then it allows you to transfer that very small amount of real estate assets to your loved ones or your heirs. It's not really going to be something that you discuss, that your members will be really interested in, because they probably don't qualify. So then we will move to the next consideration, which is asset control. And why do we talk about asset control? Generally, it makes sense to talk about asset control when you have beneficiaries or heirs that may not be as capable at managing the assets as you are. You have a lot of homes or a lot of duplexes or a lot of apartments or condos or what have you, and those require a lot of management. Your real estate empire requires somebody to guide it. And if your heirs are minors, 12, 15, up to 18 years old, they legally aren't allowed to own that property that you might be leaving to them. And so you have to make provision for what happens to all of those real estate properties, or the entities that own the real estate, while they're catching up, while they're getting old enough to manage those assets legally. But then even after they reach 18, there's a lot of questionable decisions made by 18 to 21-year-olds, right? There's lots of learning curve that still needs to be done. And so a lot of times people look at their kids and they say, okay, I don't want to hand you the keys to the kingdom till I know you can manage it. And so they want to stretch out the period of time between their passing and those keys of the kingdom finally being handed over in full. And there's a lot of reasons why you might want to do that. So one, your heirs or your beneficiaries are minors. They might have some substance control or substance abuse problems, or they may be incapacitated. They might have some disability that prevents them from fully managing the assets that you're leaving behind. And in those situations, asset control becomes very important, because you have to install somebody in your estate who can manage those assets for the benefit of your children, of your heirs, of your beneficiaries. And there are some products that we have that do that very well, and some that don't do it very well at all. So if you have an estate plan that centers on a product that just automatically delivers an asset to your heir or your beneficiary upon your passing, that doesn't offer any control whatsoever. It's just going to go, wholesale to your beneficiary. And they may not know how to handle the taxes. They may not know how to handle managing the asset at all. So we try to balance those considerations when we decide what the right estate plan is for you. The final consideration is cost. And keep in mind, these are basic considerations. There are advanced considerations that we might address. They'll probably be good for some of your members, but we'll address them towards the end. And the last one is cost. So cost, the main question is the cost worth what I'm getting? And the trade-off is, okay, if you want to avoid probate and have asset control, you're probably going to pay a higher upfront cost than you would for something that doesn't avoid probate or doesn't provide asset control. But it allows you to avoid the costs on the back end. So those are the basic considerations: is probate avoidance, asset control, and cost minimizing. And we have, when we talk to people who are trying to set up an estate plan, it's basically choose the two of those that are the most important to you. And we want to make sure that you understand what's involved in those so that you can make that choice. But basically that's it. You choose two, and then the third consideration is the one that you got to kind of let go. There's always trade-offs in estate planning. And when we talk about kind of the advanced estate planning, there's a lot more trade-offs to get those advanced benefits. But that's basically it as far as the basic consideration. So what are the products that we offer? So let's say that you have decided that probate avoidance is the most important. So if you set up a will as your primary estate plan document, you should know that that will is definitely going to go to probate. Wills have to be probated. They don't even have any legal effect until after you die, because you can always change it, and it will need to be updated. So if you want to make the will your central estate plan document, just know that that is not going to avoid probate. So the other options, we have two options. One of them that offers a lot of asset control and some asset protection, and one that doesn't offer anything in the way of asset control. So the one that doesn't offer anything in the way of asset control is what we call beneficial titling or beneficiary deeds. So if you have a real estate scheme where most of your assets are held in real estate, each one of those real estate properties can be passed to somebody else automatically upon your passing by recording a beneficiary deed. And that's very simple to do. Then it's very inexpensive. You know, the legal cost of it is probably less than $200. The recording fee is generally $30 to $50. So it's very inexpensive to move an asset automatically to somebody else by recording a beneficiary deed. And that may be the right option for you, but the downside to that option is that it offers no asset control, because that real estate asset passes immediately to the beneficiary. Other versions of this for different assets. So if you have a bank account, you can designate a beneficiary or a POD, payable on death. Investment accounts, it's the same thing. It's like designating a life insurance benefit and things of those nature, where the asset is going to be paid to or titled to somebody automatically upon your death. And all that beneficiary has to do is show up with a death certificate, boop, and then the manager of that asset has to legally transfer the title or transfer the ownership of that account. So that's one scheme. The other scheme that offers more in the way of control is what we call a trust, a revocable living trust. And for the most part, this is kind of where the bulk of our estate planning work comes in, is in constructing trusts and estate plans that are centered on trust, because control does happen to be very important to a lot of people. And with a trust, you're constructing kind of a large document. I'm going to grab a folder real quick on my desk.
Okay, go for it.
And it comes in a binder. It's all blurred out right now, which is fine, but it comes in a binder. Usually has at least a dozen, if not more, documents. Probably this one right here has like 24 documents in it. And you're constructing a contract with yourself, essentially. And a trust is a legal arrangement where you have three parties: a grantor, a trustee, and a beneficiary. And The grantor is the person who funds the trust. The trustee is the person who manages the trust and the assets in it. And the beneficiary is the person who spends the money. And they get the benefit of all the assets in the trust. During your lifetime in a revocable living trust, you are all three of those people. You're both the grantor because you funded the trust, you're managing the asset, and you're receiving the benefit of that asset. So you get to be all three. But then when you die or you become incapacitated, there are instructions in the trust already built in about what to do. And because the trust has legal effect immediately upon executing it, it doesn't need to go through probate. That's how we get around the probate issue. Now, as far as control, you can build into your trust all manner of distribution provisions, meaning how that property that you've put in trust is to be divvied out to your beneficiaries. You can stretch it out for a long time. And a lot of people, especially very wealthy people, have stretched their trusts out for a long time. That's where we get the term trust fund babies. Is the trust fund is meant to last perpetually or through at least several generations in order to preserve the family's wealth over a long time, and also prevent the beneficiaries or the kids, the grandkids, from wasting or abusing all that wealth for short-term benefits. You know, maybe they have substance abuse problems, and so they want to make sure that the money isn't squandered. And trusts are very effective at that. You set up a trustee, and if you have a lot of wealth, a lot of times you can set up an institutional trustee, which is like a bank or a financial management company, to manage the trust for you. I don't know how many millionaires you have in AZREIA, but if you have a lot of them, these are folks that might want to look into establishing a generational trust that is managed by a professional fiduciary or something along those lines. It doesn't have to go that way. Obviously, if you want that wealth to just kind of go from you to your next generation, or maybe even one generation after that, then you don't need necessarily an institutional or professional trustee. You can just have a very trusted member of the family or a friend act as trustee for you. And so that's kind of where the bulk of our business comes, is from constructing trust, because trust can be somewhat complex in their construction, whereas a will can be very simple. It's usually 10 pages or less. A trust tends to be, or at least 40 pages, can be, several hundred pages, depending on how complex you want it to be.
So Sam, so that was great. I didn't know, just having a will does not avoid probate.
That's right.
Now, what's the difference between like a beneficiary and a trustee?
Yeah, so a beneficiary is the person who gets the benefit of the asset.
Okay.
And the trustee is the person who manages the asset. They don't get to spend the money on themselves. Trustee has to give the money to the beneficiary. So think of it as like Alfred and Batman. Alfred's the trustee. He manages Wayne Manor, he manages the estate, but he doesn't do it for himself. He has to do it for Bruce Wayne. So Bruce Wayne's the beneficiary in this instance, and he gets to spend the money on whatever he wants, right? He's buying Batmobiles and Batcopters and crazy bat suits, whatever. Alfred, his job is just to make sure that the money is taken care of for Bruce Wayne to spend on whatever he wants. So when you're thinking about trustee, I want you to think Alfred. When you're thinking about beneficiary, I want you to think Bruce Wayne. Okay.
Can they be the same person if the family?
Yeah, well, it depends on the type of trust. But in a revocable living trust, the trustee and beneficiary are the same people.
Got it. Wow. Okay, cool. So are there different types of trusts? Is that kind of what you meant by all, the different asset? Well, said probate, asset control, and cost. So let's make sure I'm following right. So is there different types of trusts?
There are different types of trust, and the one I've been referring to early on for the general estate planning topic is a revocable living trust. This is a trust where the grantor, or the person who funds the trust, is also the trustee and the beneficiary during their lifetime. And that's an important distinction, because once that person dies, the trust is no longer revocable, meaning that it can be changed. It becomes irrevocable. In other words, it is kind of set in stone at that point, and you can't really amend it. And the assets put into the trust can only be taken out according to the terms of the trust.
Got it.
It usually means a payout to a beneficiary, which is usually a child or spouse or other close relative. The other type of trust is the irrevocable trust, or irrevocable living trust. And this is actually a wide category of different types of trust. And we put irrevocable living trusts or irrevocable trusts into the advanced estate planning category, because the idea behind an irrevocable trust is that you're going to get some benefit by putting some asset into this irrevocable trust, which removes your ability to control that asset for a certain period of time. So one that might come up often in the real estate industry is what we call a QPERT. They all have these like little cutesy names that are just acronyms or pronunciations of acronyms. QPERT means Qualified Personal Residence Trust. And so you can see all of them have these kind of long, complex names. And what makes the different flavors of trust or irrevocable trust depend on what's funding that trust. In this case, it's a personal residence, qualified personal residence trust, right? So personal residence. Who is the beneficiary of that trust and how long it lasts? Those are kind of the things that change one irrevocable trust, or distinguish one irrevocable trust from another. So some other examples are ILITs, which is irrevocable life insurance trust. They all have these different cutesy names. So IDGIT is a really common one, which I think is funny because I used to watch Supernatural, and there was a character who used to say idiots all the time, right? It's referring to idiots. But they all have these different functions, but they all come with trade-offs. And so that's why we call them advanced estate planning, because you have to know what the trade-off is that you're getting for the benefit. And it usually revolves around creditor protection and tax planning. So for example, the QPERT, Qualified Personal Residence Trust, what happens there is the grantor, or the owner of the house, puts this property into a trust for the benefit of usually children. And then it's for a certain amount of time. And at the end of that time frame, the children become the fully vested owners of the property. And the original grantor now has to either pay them rent or move out. They don't get to be owner of that property anymore. And during the course of it, they get to keep it out of their estate. It's not part of their estate. It belongs to the trustee for the benefit of the beneficiaries. And it comes with some tax drawbacks, but it gives you creditor protection. So that's why when we talk about irrevocable trust, that's like Baskin Robbins. There's 31 flavors of irrevocable trust, and determining which one is the right for you is a pretty involved exercise. And it just depends on, the asset and your financial, the financial goal you're trying to accomplish by putting it in trust.
Is there a time frame, like whether you're a new investor, maybe you don't have any properties, maybe you have one property, or seasoned, like is there like a minimum that you recommend someone be at before they even go down this road as a real estate investor?
Yeah, so we look at irrevocable trusts when we're starting to get close to a hefty estate plan, or sorry, a hefty estate tax liability. So right now, that amount is $12.07 million per individual. In 2026, it's scheduled to drop to, I think, 6 million. That threshold for estate tax could drop to 6 million. So if your real estate portfolio, and keep in mind, this only relates to the equity part of the real estate. If you have significant loans against your properties, you have to factor those in when you calculate the amount that your estate is. So if you have, $4 million homes, or $2 million homes, or $3 million homes, but they also have significant loans on them, then you have to subtract the amount of the loans from those calculations. But when you're approaching the estate plan, or sorry, I keep saying estate plan, estate tax threshold, that's when we really need to start looking at the irrevocable trust option in order to plan for any taxes that may be coming out, and creditors that may be after your assets. That's another thing is, if you think that you're going to have a problem with creditors, you have to do this irrevocable trust thing well in advance. Otherwise, it's going to become fraudulent conveyance under the state of Arizona statutes. And for fraudulent conveyances, if a court finds that it is a fraudulent conveyance, which is a technical term, it doesn't mean that you're trying to defraud somebody. It means that you have debts and then you move that asset out of your estate. That's it. That's all it means. You have creditors, and they may want to seek to attach that asset, and then you transfer that asset for nominal or no money. Then that could be considered a fraudulent conveyance.
So if you have, if you have property and then you pass away and you have debt, the creditors can come after those properties. But if they're in the trust beforehand, they can?
Well, it depends. If we're talking about irrevocable trust, that's correct.
Okay.
If we're talking about a revocable living trust, it's going to depend. Sometimes they can, and sometimes they can't. When you become, or when you die, your trust becomes irrevocable, and so in certain cases, it becomes a protection against those creditors after you pass away, but not necessarily. So we have to make sure that it's structured properly in order to give that kind of protection to your heirs or your beneficiaries, in order to make sure that the creditors aren't banging on their door asking for money or handouts or anything like that. So irrevocable trusts, they come with trade-offs.
Okay.
And so it's usually a necessity in order to avoid some hefty creditor attachments or hefty tax bills. That's usually what we're trying to do when we set up an irrevocable living trust. I do have a client who is looking to set up an irrevocable trust to protect a residence for the benefit of his wife and kids while he is seeking care, like a retirement home or a nursing home care. And so we have to construct a trust that's going to accomplish that goal, but it's going to come with trade-offs. For example, with a QPERT, it's possible that they don't get that step up in basis because it's a lifetime transfer. And that's I don't know how much you guys know about capital gains taxes, but the basis is whatever you paid for that particular asset. And then when you sell it, there's the capital gain. Well, if you inherit something, meaning you didn't pay for it, your parents paid for it, generally there's a step up in basis at the time that moves it from what your parents paid to what it was worth at the time that you inherited it. But if you do a QPERT, that step up in basis doesn't happen because it's a transfer during the lifetime of the grantor.
So the tax strategy has to be handled when the trust is created. Like am I thinking right? Like, so you put your all your assets in a trust, you pass away, your family takes it over, they sell all the houses, there's a huge profit. That family member, they can't do anything to minimize taxes at that time in the future. Is that something you have to do in the beginning?
So generally, again, we're kind of mixing the basics with some advanced stuff. I want to keep that clear. When we talk about irrevocable living trust, that's definitely advanced estate planning topics. As far as capital gains going with normal revocable living trusts, that tax consideration is already in our mind, and it's already kind of built in because it's inheritance. It's just like anything that you might inherit through the probate process or through a will. It gets a step up in basis because it's not a transfer during the lifetime of the grantor. It's a transfer after their death. And so it does receive the benefit of that step up in basis. And all that means is that when you sell that asset, that less of the gain gets taxed than it would otherwise. Like you still might have to pay a capital gains tax, but less of the proceeds of that sale would be considered taxable income than it would otherwise. So step up in basis is a good thing. And for the most part, transferring your assets during your lifetime to your heirs or your children or your beneficiaries does not afford that step up in basis. And so when you're talking about tax considerations, then yeah, you may want to sit down with a lawyer or an accountant and work out what those tax consequences may be. But for anything that's inherited after death, it's a different story. Like that's automatically you get that step up in basis. So
awesome.
So yeah, so when we're looking at trusts, trusts have several different properties to them. They allow, one of the things that I often will talk about is the time frame in which each of these documents operates. So in our estate plans, for example, we have 4 primary documents. We have the trust, we have a will or a pour over will, we have a power of attorney, and a healthcare power of attorney. Powers of attorney only operate during the lifetime of the person who's signing that power of attorney. A will only operates after that person dies. So someone who has power of attorney can't go and move your assets after you die for you. They can't do that. Their authority ceased when you died. Someone who has designated your personal representative under your will can't do anything for you while you're alive unless they're also your power of attorney. A trust, on the other hand, if you have a trust, it actually bridges the gap between before your death and after your death, because it is operational as soon as you sign it, and it continues to function after you die. And so you have to kind of understand how each of these documents works together in order to accomplish the goals that you have in mind. So when we put together these estate plans, we include all of those documents. And I spend time, I don't know that every firm out there will spend time telling you what they're used for, but I try to educate my clients so that they understand that the power of attorneys for paying your bills while you're in the hospital, or maybe you're on a trip in Europe or Asia or something, and you're off having a good time and you forgot to pay the electricity. Well, you can have your power of attorney agent sign a check out of your bank account on your behalf with that power of attorney. And that's great. That's fine. That's what it's for. On the will side of things, if you have a personal representative, they can take your assets for you and transfer them where they need to go. They can make sure that your kids are signed up with the proper guardian that you've designated for them. They can institute legal actions on your behalf, or they can defend legal actions on your behalf, meaning they can hire an attorney on behalf of your estate to defend it or to prosecute it. So that's where that operates. Now, a trustee, if you're incapacitated during your lifetime, your trustee has the ability to manage any assets in the trust for you. And likewise, after you die, that same trustee doesn't need to go to court to get the authority to act on behalf of the trust. They already have it. So you want to make sure that you understand how those things kind of link together, where they fit in. And with the trust, the trustee has full authority for any assets in the trust. But anything that you have outside the trust, you've got to give them authorization to put those assets in the trust. And you can separate all of those roles, but for the most part, people don't. They like to have the same person as their power of attorney, same person as their trustee, same person as their personal representative, because then you have just one person who has to track where everything's at instead of treating them all separately. And then you have all these different things that you've got to keep track of.
I have a question here, Sam.
Yeah.
And Roger, if you can clarify, if we don't touch it, how soon should you get an attorney if you're a beginning investor? I guess
if you're beginning investing?
Yeah, I guess it just depends what you're looking to do. This is in regards to estate planning. So if you could answer at that level.
Okay, well, I'll tell you that it's always a question of risk and what you stand to lose by not getting an attorney. So, for example, I have a client who put together a rent-to-own agreement for one of his properties. I strongly discourage rent-to-own agreements because if you're renting, an eviction takes less than a month to complete. It's very fast. It's the fastest legal proceeding that there is. There's almost no faster legal proceeding. If you are selling a property outright to somebody and they default on their mortgage, then you can do a deed of trust and do a foreclosure, a non-judicial foreclosure in 90 days. It's very fast. If you have a lien, like a mechanic's lien on a property, and you want to foreclose that mechanic's lien, it usually takes about a year to get through that mechanic's lien. If you do a rent to own, you basically have to do all three of those legal proceedings. The first thing you do in a rent to own is when they default, you have to record what's called a notice of election to forfeit, which gives them 30-ish days to come up with the money, which if they don't, then what do? Well, you have to file a lawsuit at that point to quiet title and make sure that their interest in the property is foreclosed. And that's a judicial lawsuit. And then once the quiet title action is ended, then you can do the eviction, which is again another 30 days. So you're looking at 30 days at the beginning, another year in the middle, and then another 30 days at the end. All during that time, your tenant is not paying any rent. And that's a quick version, like that's fast. My client hasn't been paid rent in almost 16 months.
Wow.
So he is losing money because he didn't hire a lawyer at the beginning to explain to him what the consequences of a rent to own would be. And that cost at the beginning would have been less than $1,000, I'm sure.
Yeah, because the guy selling the education course on rent to own online isn't going to go over all that. You know what I mean? So yeah, that's huge. Yeah, so hopefully, Roger, that kind of gives you an idea. I think sooner the better if you can afford it, right? So I know sometimes that can be an issue when you're just kicking off. So,
yeah. And so it's that kind of weighing problem is you look at what you stand to lose if you don't get a lawyer and compare that to what it costs to have a lawyer. For example, you might have a small business proposition with some friends. Maybe the amount of assets involved is less than $1,000, and it's probably going to cost more to get a lawyer to sort that out than the assets in the business at that time. You know, if you're setting up a lemonade stand, for example, you don't want to have a lawyer come out and give you a full-blown operating agreement, but you may want to have a lawyer do your permitting for you. So it's a question of balancing what assets you have in your business versus what it would cost to be a lawyer or to get a lawyer. And for the most part, getting a lawyer is going to cost a lot less than what you stand to lose for the errors that you'll commit by not getting a lawyer.
Awesome. And I just want to jump in. So if you're online, I hear on the Zoom call, if you have any questions for Sam before we wrap it up, it's just about to be 1 o'clock. I want to make sure I get your questions answered. And while we wait for that, Sam, if someone's ready to get started on estate planning, or start looking into it, is there like a checklist or like a couple items you can kind of share with us, like before they sit down with an attorney or with yourself, like, hey, make sure you do this type of research. You have these names, is there a little checklist they should start doing before they sit down with you or someone else?
Yeah. So the thing that I always try to focus my clients on are, what are those concerns that they have? We went over the 3 of them in our review. So probate avoidance, asset control, and cost minimization. And then if asset control is an important issue for you, then I would say make sure that you are thinking about what it would take to address those asset control concerns. It may just mean spreading things out until your kids get older. It may mean, drug tests if you're concerned about substance abuse. And it may be something very simple that we can talk about together. Also, you're going to want to identify your assets that are going to be funding the trust. And that requires you to list all of your properties and know where they're at. Business holdings, oil, gas, mineral rights that you might have, bank accounts, investment accounts, all that stuff. But generally, that's a questionnaire that we provide also. So it's just a matter of filling it out and identifying those assets for you. And the great thing about a revocable trust is that if you miss something, you don't have to go back and start all over. You can just add that asset to your trust at any point during your lifetime. So they're pretty flexible. That's why they're very popular estate planning product. And it's a really great thing. So if you haven't really thought a whole lot about it, I don't want you to be too worried about that. I basically look at my role as like an estate planning genie. You tell me your wishes and I put you with the right product that accomplishes them, that grants those wishes. And so if you're new to thinking about it, you just want to kind of work things out with a lawyer, feel free to give me a call and we'll work it out.
Yeah, we got Sam's information here, sam@focuscompanies.com, 602-457-2191. I love Phocus Law, Mick, Sam, the whole staff over there. Everybody's always great, treats me right. So, so we can reach out to you. If you have any other estate questions, let me see. I don't know if I saw any other questions pop in. Cool. So that's what we got for questions. Just before we sign off, oh man, what did I do here? Next week, we have his good friend Seth coming in to talk about the Inflation Reduction Act of 2022. How does it impact real estate investors? I know they just hired 87,000 new IRS agents, so maybe we're going to dive into that and just
with guns.
I saw some video, but I didn't dive into that. That's probably a whole nother story we can talk about, man. But yeah, so join us next week, Wednesday at 12 p.m. with Seth. But Sam, any last words you want to leave with us?
Estate planning is something that you do to prepare for untimely demise, really. So it's not something that you'd want to put off for very long, especially as your assets are growing. You can always change it. You have a plan, you can always change your plans, but don't go through life without a plan. Plans change, and that's fine. But if you don't have a plan, bad things happen.
Yes, sir. And unfortunately, we go any day, man. So be prepared. Help your loved ones out. So, love it. Thank you for being here, Sam.
My pleasure.
I'm sure I'll be seeing you around. We're working together on a few things. So, everyone, have a great week. Have a great day. Go write some offers, and I will see everyone next week. Thank you.